The moment my son-in-law walked into the boardroom without holding the door for me, I knew exactly what kind of meeting this was going to be. His name is Matteo. 34 years old, Rotman MBA, the kind of guy who refers to his father-in-law by first name in professional settings because he read somewhere that it signals confidence. He sat down across from me at the long oak table like he was doing me a favor just by showing up, loosened his jacket, set his phone face up on the table so everyone could see the notifications rolling in. I'm Colin, 57 years old. I'd spent 29 years at Lakeshore Facility Holdings, a commercial property management company out of Burlington, Ontario, that started as 4 people in a rented office above a Vietnamese restaurant on Brant Street and grew into one of the largest mid-market industrial landlords in the Golden Horseshoe. We managed warehouses, distribution centers, flex industrial spaces. Boring work, people always said. The kind of thing that keeps the economy moving but nobody writes articles about. I built the lease portfolio, not helped build it. Built it. When we were scrappy, and nobody would give us a second look, I was the one cold-calling logistics companies out of a spiral-bound notebook, driving out to Brampton and Mississauga and Hamilton to shake hands with operations managers who actually ran the buildings. I negotiated the anchor tenant agreements that gave us the credibility to expand. I structured the long-term lease frameworks that eventually made us attractive enough for the private equity group that acquired us 6 years ago. After the acquisition, the PE firm brought in professional management. Fair enough, that's how it goes. My boss for the last 5 years had been the company's founder, who stayed on as chairman after the deal closed. He trusted me, gave me latitude. We understood each other the way people do when they've been through the same difficult years together. Then his daughter married Matteo. And Matteo, it turned out, had opinions about operational efficiency. He'd been angling for a real role for 2 years. Consulting projects, advisory titles, that kind of thing. 6 months ago, the chairman quietly made him VP of Transformation, one of those titles that means everything and nothing simultaneously. Matteo interpreted it as meaning everything. He hadn't managed a single lease negotiation, hadn't visited a property beyond the flagship location in Oakville that we took clients to because it photographed well, hadn't sat across from a tenant threatening to break a lease at 11 p.m. on a Thursday because their loading dock spec was off by 6 inches. But he had a fresh set of ideas about AI-driven asset optimization, and a father-in-law who loved his daughter. I should have seen it coming. The small things accumulated. Matteo stopped copying me on tenant communication threads, started scheduling strategy sessions I wasn't invited to, referred to the legacy lease structure as inherited complexity in a board presentation I wasn't supposed to see but did anyway, because Linda in operations has been my friend for 22 years, and she forwarded it without comment. The meeting was called for 9 in the morning on a Tuesday in March, late winter in Burlington. The lake still iron gray, the parking lot half slush, the kind of day that makes you question every life decision that led you to Southern Ontario. I drove in early, stopped at the Tim Hortons on Appleby, got a large double-double. Force of habit. Matteo was already there when I arrived. He'd brought 2 people from the transformation team I barely recognized. The HR director was in the corner with a folder on her lap, which told me everything before anyone said a word. He didn't waste time. Colin, he said, the company is moving toward a fully integrated property intelligence platform. The new direction requires a different skill set at the portfolio management level. We appreciate your foundational contributions, but we're restructuring the senior lease function and your position is being eliminated. Foundational contributions. I'd heard that phrase in the original video somehow. It's the kind of corporate language that's specifically designed to make 29 years sound like something that happened a long time ago to someone else. I didn't argue. Didn't ask to see the severance offer twice, didn't make a speech, didn't let him see my face do anything it didn't want to do. Shook the HR director's hand. Said I'd have my things out by Friday. Matteo looked surprised, like he'd expected pushback and had prepared for it, and was mildly annoyed I'd denied him the performance. I walked out through the open office. Couple of people looked up from their screens. A few nodded. Nobody said anything. That's the other thing about being let go in a mid-sized company. Everyone who witnessed it spends the next week acting like they didn't. I drove to the marina on Lakeshore Road. Parked and sat there with my coffee going cold. The lake looked the same as it always had. Indifferent, patient. I wasn't thinking about Matteo. I was thinking about a filing cabinet in the storage room of my home office, the one I'd been meaning to go through for years. Dark green two-drawer, the kind of thing you buy at a Staples going out of business sale in 2009 and never replace because it works fine. In that cabinet was a folder. And in that folder were documents I hadn't looked at in a very long time. Here's something people don't understand about the early days of a growing company. Legal housekeeping doesn't happen on schedule. It happens in the gaps between crises, which means sometimes it doesn't happen at all. In 2010 and 2011, Lakeshore was in the middle of aggressive expansion. We were signing tenants faster than our legal team could process the paperwork properly. The chairman was personally guaranteeing credit lines. There was a 6-month stretch where payroll cleared by days, not weeks. During that period, I personally negotiated and executed 3 anchor lease agreements in the Halton and Hamilton regions. Long-term deals, 15 and 20-year terms, with industrial tenants who'd followed me over from a previous employer because they trusted my word. The kind of relationships that take a decade to build, because the company's legal entity was in the middle of a restructuring at the time. We were converting from a partnership to a corporation for tax reasons, and the new numbered company wasn't fully registered. Those leases were signed under my name, personally, as the contracting party. The plan was always to formally assign them to the company entity once the corporate structure was sorted out. My old colleague Parveen, she'd been a commercial real estate lawyer in Mississauga before she retired, and we'd worked together on half a dozen deals over the years, had flagged it at the time. Colin, she'd said over the phone, "I know you trust these people, but get the assignment in writing. Don't let this sit. I got busy." They got busy. The assignments were drafted but never executed. New legal counsel came in during the PE acquisition due diligence, flagged the gap, and the chairman's team had prepared a ratification agreement that was supposed to clean everything up. I signed it. Then the PE lawyers revised it. Then it went back and forth. Then someone left the legal department and the file got transferred. Then the pandemic hit. Then everything else. The ratification was never finalized, which meant, as far as the land registry office and the original lease documents were concerned, Colin Patrick Hargreave, that's me, was still the named party on 3 industrial lease agreements covering a combined 847,000 square feet of distribution space occupied by tenants generating roughly $14 million a year in rent. Parveen had buried something else in those original documents. A quiet clause, the kind of thing that looks like standard boilerplate until you actually need it. She'd insisted on it, and I'd agreed without fully understanding at the time why she felt so strongly. It said, in the event of material breach of any service, employment, or operational agreement between the contracting party and the property management entity, all rights and obligations under this lease revert exclusively to the named contracting party pending formal written reassignment. I'd been terminated without cause. That was a material breach. I drove home, changed out of my work clothes, made a pot of coffee. My daughter was at school. She's 12 and has opinions about everything, and I didn't want her to see me rattled. My wife had left 3 years ago, amicably, which is to say painfully and quietly, the way most things that matter end. The house still felt like hers sometimes. I'd kept her plants alive, which I consider my most underrated accomplishment. I opened the green filing cabinet. The folder was exactly where I'd left it. 15 years of dust on the tab, my own handwriting. Halton Hamilton Originals. Do not disca. I sat down at the kitchen table with a mug and read through every page. Then I opened my laptop and pulled up the Ontario Land Registry records online. Typed in the property addresses one by one. The leases were still in my name. All 3, the ratification had never been registered. I sent an email to Parveen that night. Short. Attached the executed originals. Asked her one question. Does the clause still hold? She called me the next morning. I could hear her grandkids in the background. She'd been retired for 4 years and she picked up anyway. Colin, she said, I want you to listen carefully. Those lease agreements, as recorded with the province, name you as the contracting party. The tenants have been paying Lakeshore on your behalf under an informal arrangement that was never legally formalized. The clause Isa wrote into the originals, and she was very careful about that language, I want you to know, would survive any number of corporate restructurings because it attached the documents themselves, not the relationship. Is it clean? I asked. She paused. I asked. Clean enough. You didn't do anything wrong. You've been operating in good faith for 15 years. The problem is entirely on their side. What happens if I don't assign them? Another pause, longer this time. Then she said, the tenants are technically making payments to an arrangement that names you. If you were to formally notify them of your status as the contracting party, and more importantly, notify the property management company, they'd have a significant problem. Because every rent payment, every lease renewal, every operational decision made under those agreements for the last several years would need to be re-examined. Let that sit for a moment. This isn't what I thought it was in 2010, I says. No, she said quietly. It isn't. But you didn't create this situation, Colin. They did. And then they fired the only person who understood what they were sitting on. I thanked her. Hung up, got my daughter from school, made her pasta, helped her with a geography project about the St. Lawrence Seaway. She told me 3 jokes. 2 of them were actually funny. That night, after she was asleep, I sat at the kitchen table and thought for a long time. I want to be clear about something. I'm not a vindictive person. I'd given 29 years to that company because I genuinely believed in what we were building. The chairman had been good to me for most of that time. There were people at Lakeshore I considered real friends. This wasn't about burning anything down. But Matteo had fired me without cause, without a conversation, without a single acknowledgement that 20 zao sent something. He'd sat across from me like I was a line item and told me my contributions were foundational, past tense, and gestured at the door. Parveen had been right in 2010. I hadn't listened carefully enough then. I was listening now. I drafted a formal notice to the 3 anchor tenants. Polite, precise, legally clean. Parveen reviewed every word. The notice explained that as the named contracting party on their lease agreements, I was reaching out to clarify the current legal standing of their tenancy arrangements, and to advise them that any future lease actions, renewals, or modifications would require my written authorization as the party of record. I didn't send it immediately. I waited. Lakeshore's Q2 portfolio review was scheduled for the following month. It was a big one. The PE firm's investment committee was coming in from Toronto. They were finalizing plans for a major refinancing of the Halton assets, and the 3 properties under my agreements were specifically cited in the deal materials I'd helped prepare before my termination. I knew the refinancing timeline. I knew which bank they were using. I knew that the due diligence process would involve a title review. I waited until the week before the bank's due diligence was scheduled to begin. Then I sent the notices. I also sent a registered letter to Lakeshore's general counsel, a careful, measured document that outlined the history of the original lease agreements, the incomplete ratification process, and my position as named contracting party under the land registry records. I attached everything. The originals, the correspondence from 2011, the draft ratification that had never been executed, and the specific clause that Parveen had insisted on. The letter ended simply. I am available to discuss a formal resolution at your earliest convenience. I didn't threaten anything. I didn't have to. I imagined the moment it landed. Someone in legal would have read it, gone quiet, then pulled up the land registry, refreshed the screen, pulled up the lease originals, refreshed again, then walked down the hall to the general counsel's office with the particular expression of someone who has found an unexploded device in the company's foundation. I heard later, from Linda, who still texts me occasionally, that the discovery triggered an emergency meeting that same afternoon. The refinancing bank was due to start their title review in 4 business days. The 3 properties in question represented about 40% of the assets in the refinancing package. Matteo reportedly called it a clerical error. The bank did not consider it a clerical error. When external counsel is reviewing title documentation for a 9-figure refinancing and the 3 largest properties in the portfolio come back with a named individual as the contracting party rather than the corporate entity, that's not a clerical error. That's a material title defect that triggers a hold on the entire transaction. The refinancing was paused. I got a call from the chairman that evening. I hadn't spoken to him directly in months, since before Matteo's ascent had reshaping the reporting lines. His voice sounded exactly the way I remembered it from the hard years. Tired. Careful. Colin, he said. Just my name. No greeting. I know why you're calling, I said. A pause. Then, how bad is it? I told him the truth. I said the legal position is clean on my end. Parveen reviewed everything. I'm the party of record. That's not disputable. What's disputable is whether we can resolve this without it becoming a problem for anyone. Why didn't you ever push for the ratification? I let that sit between us for a moment. Because you asked me to trust that it would get done, I said. And I did. For 15 years. The line was quiet long enough that I thought the call had dropped. Then he said, I need to fix this. Yes, I said. You do. I didn't slam the phone down. I just waited until he said goodbye, then set it gently on the counter. The following morning, I received a formal email from Lakeshore's external counsel. It was professionally worded and careful and asked whether I would be open to a meeting to discuss a resolution. I replied that I would. The meeting took place in a boardroom at a law firm on Bay Street, neutral territory. I brought Parveen. They brought external counsel and the chairman, and notably not Matteo. We sat down, coffee was poured. Nobody was rude. This is how things actually work in commercial real estate in Canada. Everyone is professionally civil right up until they're not, and both sides know the difference. They wanted an immediate assignment of the leases. Clean transfer, back to the company, everything as it should have been in 2012. I had a list. First, I wanted a formal documented acknowledgement that my termination had been without cause, and the severance package adjusted accordingly. In Ontario, 29 years of service with no performance issues and no misconduct creates a common law notice obligation that's serious. They'd offered me 8 weeks. My number was different. Second, I wanted a consulting agreement. Specifically, the 3 anchor tenants, all of whom I'd originally brought to the company, had flagged concerns when they received my notice. They wanted continuity. I was willing to provide it on a retainer basis for an 18-month transition period. Third, I wanted a written acknowledgement distributed internally that my portfolio work had been central to the company's growth over 3 decades. Not a press release, not a LinkedIn post, just a memo. Something honest. And 4, asked that Matteo be removed from any file or decision that touched the legacy portfolio. That last one was the only one they pushed back on, briefly. Then they stopped pushing. We shook hands 3 hours later. The lease assignments were executed the following week. The refinancing proceeded on a revised timeline. The bank closed the deal 6 weeks after the pause. I got a call from the lead tenant, a logistics company out of Brampton that I'd first signed in 2009, same year as the original filings. The operations director had worked with me for 15 years. He said, I don't know exactly what happened, Colin. But whatever it was, I'm glad you're still involved. That meant more than the settlement number, honestly. My daughter asked me one evening why I seemed lighter. She's 12 and notices everything. I told her I'd sorted out a work problem. She nodded like that was a reasonable amount of information and went back to her book. She's right to not need the full story. The full story is long and complicated and involves a lot of paperwork. The short version is, I spent 20 years doing careful, honest work. I kept records. I had a colleague who knew what she was doing. And when someone decided that all of that could be erased with a Tuesday morning boardroom meeting, they forgot one important thing. The papers they forgot to file had my name on them. Not the company's. Mine. Last I heard, Matteo had transitioned into a senior role at his brother's marketing firm in Etobicoke. The transformation initiative was quietly wound down. Lakeshore brought in a new VP of portfolio management with 20 years of experience in industrial leasing and the sense to read the original documents before signing anything. The green filing cabinet is still in my home office. I'm not going to get rid of it. Some things you just keep.